Mr. Murray, this is a courtroom. Please do not smoke while you're in court. You're really close to being held in contempt at this point, Mr. Murray. Please have more respect for the court of law.
We're here today for the contract breach of the trailer. We went into a rent-to-own contract, $750 a month for the space rent and $250 a month for the actual trailer. It was a rent-to-own. That $250 a month would have lasted about 36 months for the total to be paid off. And we're basically here to get that back because of the contract termination, and as well as all the fixes and parts that had to be put into it.
But
it specifically states $1,000 a month for 36 months. That is $750 a month for space rent. That's $250 a month for the trailer rent plus $1,000 deposit. So we were paid up throughout the end of July because of, everything that was going on, the hostility, the harassment. We decided that it was best that we move on. We were paid out to the end of July. We were trying to find a place to take the trailer. And I had to come down here to Coos Bay for an interview one weekend. So we drove down here that weekend. We had, taken a couple truckloads out to storage to make things a little bit easier, when it was finally time to move. And on our way down here for my interview that weekend, we got a text message from him with, some language and calling me a druggie and a crankster, to be exact. And that I'm not allowed back on the property, and that he's killed the water and power and everything else to the trailer. I advised him that I still have my things there. We still live there, and we're paid out to the end of July. And he told me I'm not allowed back on the property. I can come get my stuff as long as he's with me, but everything else is locked out.
So, and I think I did remember reading this, but was there any eviction proceedings?
Negative. He, going back when everything first started, he was trying to fight me at his house there, or at his mother-in-law's house, and ended up punching a thing right next to me, and then yelled at me that I've got 24 hours to get the trailer and the vehicles out, or he was going to tow them. So I don't know if that's considered an eviction, but there was no official eviction letters done besides just verbal, I'm going to tow your stuff, you need to get out now, don't come back, kind of thing.
Well, basically, it's pretty simple. It's $1,000 a month for 36 months. They moved out on month 14, 15. I can't remember which one it was, but we have receipts for all that. So they paid everything like they were supposed to. They moved out. They never received an eviction notice. They never received anything. This trailer was something that I brought up there that I got from my buddy, and we set it up for $1,000 a month for 36 months. The title will be signed over to him when he pays the 36 month. He can pull it off the property. He can do whatever it is he wants to do. Good to go. They only made it 14 or 15 months. I never gave them nothing. I don't know. They just moved out. I locked the water. First of all, the power was never locked out. It was hardwired. I put a lock on the water because the neighbors came over and told me that they were going to flood the trailer. So that's what I did. Now, they never told me they needed it unlocked or anything like that. So I'm like, okay, well, I ain't going to take a chance at my trailer getting ruined. So second of all is as far as all the parts being bought, absolutely. That was very respectful of him to say, yeah, I paid for half of that, because the first week they moved in, they had a problem with the hot water tank. Okay, it's not my responsibility to pay for half of their hot water tank, but I did it to be, whatever. They're a new tenant. So if you want a hot water tank, I'll pay for half of it. No big deal. Okay. I don't know about any of the other repairs. Did not know about anything. Did not receive any bills for these. It's not my responsibility to fix his trailer, nor is it my responsibility to let him pull a trailer out of there on month 15 when the contract has not been fulfilled. And neither do I own the property, or do I even have anything to do with the property other than just helping the 80-year-old woman that owns it run it. That's it. So
Wait, so you don't, how was so the contract, was it entered with the property owner or you?
the rental agreement was, and it's really not a contract, it's a rental agreement. What was
Well, a rental
given to
agreement
you.
is,
It's a what?
it is kind of a contract. That is a written document where
Oh.
parties have come to consideration in terms.
Okay, that was written by the homeowner.
Okay, so not you?
No, ma'am.
So,
And all this stuff was in there. And as far as the roof caulking, I mean, I just chuckle on that because I ordered a whole case of roof caulking off of my Amazon Prime account and gave it to him. So why am I being charged for something that I ordered on my account and just handed it to him? So I don't really know.
okay, I need to hold on. So the contract for this is $1,000 a month, but it's broken down, correct? $750 for the space and $250 for a rent to own for the trailer. Or the
Yes.
fifth wheel, right? Okay, so that contract was entered not with you, but the property owner?
Yes, ma'am.
Then how do you have any authority to evict them?
Yeah, that's what I'm wondering. And I didn't evict them.
Oh. But you locked the water, you parked cars and threatened to park cars in front of, so they couldn't take it. At
Right.
least that's
They
what your
can't.
text messages said. So you said there's nothing stopping them from taking the fifth wheel off the property, but you did.
Yeah, they can't take the fifth wheel off the property until the 36th month. Did you read the rental agreement?
Oh, sir. All right. If you can't keep things civil, we're gonna have a tough time here. So,
Okay.
reminder for you to keep things civil. This is a court of law. I'm a judge, so please remember that there's certain courtroom decorum that you must follow.
Okay.
Okay. Well, and how does your mother-in-law have the authority to rent out the fifth wheel
Because what had happened is
for rent to own?
my buddy gave me the fifth wheel, said, take it. I'm done with it. They couldn't find the title. I said, okay, I've got a tenant that wants to move in, or a couple that wants to move into this. Did it 36 months, $1,000 a month, however you want to break it down. And so that would give a time to file for the lost title or whatever needed to be done. 36 months. We should have been able to get a title. It's paid for. So
Isn't it your trailer or your fifth wheel?
Well, he gave it to me, but it's not legally mine yet because we don't have the paperwork.
So how do you have any authority to enter this in agreement and also turn the water off and tell them they can't come back to the property and park in front of the fifth wheel? That I'm just struggling to understand your involvement in all of this. If you're not the owner of the property, the owner of the fifth wheel, and I don't see any authorization for you to do that.
Okay.
I'm asking you.
I don't know.
Okay. So they just randomly decided to just stop renting the fifth wheel. I guess in your understanding, what kind of was the breakdown?
The breakdown was they just started moving out.
That's okay.
That was the breakdown. So now they want all this money for moving out. If I don't have the authority to evict them, like you're stating, why did they move out?
Well, they're saying they didn't move out.
They did.
They were forced to move out.
They took truckloads and truckloads out of there, and then they threatened me to ruin the trailer. That's why there was a vehicle parked there. That's why the water was.
But you said that was a neighbor said that they were going to flood the trailer, not them.
The neighbor told me that, and also they did too. The neighbor wrote a letter for you.
I read.
Okay.
The problem is you're kind of giving me conflicting information right now.
Well, it's hard to remember every little thing
Sure.
when you got 4 trailers up there.
I understand. So it's your testimony today that you, I guess, you're saying they moved out, so therefore the contract was just done?
Yes, the contract was done. They were to receive a title on the 36th month. They moved out. Sorry, I don't know what else to say.
Okay, but the text messages show that it's not just them moving out.
Okay, what does it show?
You're involved with these text messages. I'm asking you I'm asking you what.
Yeah,
A lot of this is.
I said some things that I probably shouldn't have said, but I was pissed off.
I can see that.
But they didn't, I didn't tell them that, I didn't make them moved out. They were already moving out. They had already took truckloads off the property.
Because it sounded like it was becoming kind of a. Let's see. And they paid through July? Is that accurate?
I'd have to look, but I think that's pretty darn accurate. It was 14 or 15 months, ma'am, that they made it.
So, but they paid through July, but you locked them out of, and you didn't allow them to take the fifth wheel off the trailer through the month of July.
Didn't allow them to what?
Take the fifth wheel off the property?
Yeah, it was never allowed to go off the property until
But you didn't allow
36th.
them to come to it either because you were worried that they were going to flood the trailer based off what your neighbor said.
Yes, but that doesn't mean that they couldn't have came to it. That's why they were taking
But
truckloads up.
you locked the water. How are they supposed to return to that if you've locked the water? And they said that you turned off the power as well.
No,
How
I
are they
did not.
supposed, regardless, how are they
Yeah.
supposed to come back with no water? That's not a habitable living environment, and you would be in a lot more trouble if that were the case.
Okay.
So for this month of July, this month of July, they paid the full month of July. And you basically shut off the water, locked them out of you parked the truck in front of the fifth wheel so they couldn't take it off in the middle of July. So they could not benefit from the enjoyment of the property they had paid for.
Right. Yep.
So you're not disputing this $150 for the rent of July?
No.
Okay. So it's your understanding that they just moved out. There was no, they didn't have any issues or anything they brought to your attention?
No, the issues were starting to rise. And when I put my foot down that it's not going to happen like that on my mother-in-law's property, then they started.
What's not going to happen like what?
What's not going to happen? Him cruising down the driveway at 30 miles an hour and almost hitting little kids. Drugs being on the property. That's not going to happen.
Okay.
So that's the way it, I'm sorry, but that's not.
I have no evidence to support that except for your testimony, so that's fine. But that is not in the lease agreement, in the rental agreement that you have. There's nothing indicating.
Well, the rental
that's a basis for termination. But you're the one acting in authority for your mother-in-law. You are the one that is clearly discussing and communicating with these tenants. And I'm guessing with the other tenants that are in the fifth wheels on that property as well?
Absolutely.
Okay, so you are acting on authority of your mother-in-law.
Yep.
Okay, so you do have authority to evict people or turn water off or do any other things that were requested by a tenant?
With the proper documentation.
What do you mean proper documentation?
Well, if you do an eviction, you serve them papers.
Correct. And if you cut off water, isn't that a constructive eviction?
No.
How so?
Because I'm not going to have a trailer ruined.
But you don't know this.
Okay.
You're talking about something that I'm just asking. You shut off the water. Shutting off water makes a living situation uninhabitable.
Okay.
No, that's accurate.
Do what you want to do.
Okay, well, if you have nothing further to say, then I will turn the attention back to Mr. Sims and Ms. Weicker. Can you please mute yourself, Mr. Murray?
All right. I'm unmuted
Mr.
here.
Murray, this is a courtroom. Please do not smoke while you're in court.
Oh.
You're really close to being held in contempt at this point, Mr. Murray. Please have more respect for the court of law.
Yep.
And you actually did cut off water.
Water, not electricity.
Okay. Do you see how a tenant or somebody that you are, acting as a landlord to somebody, how somebody could take that as like, you're going to cut off electricity and the water. I can't live in this place anymore.
Yeah, but they already started to move out, so that's why I did
But
that.
they paid through the full month of July.
Okay. That's fine.
So but they paid through the full month of July. Aren't they entitled to the enjoyment of that through the full month of July?
Well, probably. It's just I was a little bit worried about ruining the trailer, so that's what was going through my brain. So yeah,
But that's not a legal basis to.
Okay. Well, nothing's legal about this though. The rental agreement's not legal. It's not notarized. I mean, I don't know what else to say. I mean, if I need to pay for July, then I'll pay for July. But I shouldn't have to pay for something that, number one, couldn't be taken off the property until the 36th month. Number two is, I don't know. I never authorized any of these repairs. So do you just buy a used vehicle and the guy has to repair it the whole time that you're making payments on it? I mean, that don't even make sense.
So what is your position when they brought up the fact that you said, like I said, I took 100,000 or 1,000 times 36. You are on month 15 with a full deposit paid. So on the first, why don't you hook onto trailer with a fifth wheel truck? And we are even. I will get you paperwork for trailer. You owe me nothing. I owe you nothing. That's what I was trying to call about.
Because I was gonna try to work with them until they started giving me a bunch of grief. And I called the attorney and he said, absolutely not. He said, Dean, they moved out on their own.
But then, but the problem is you have a writing in the text message.
Okay.
That does modify the agreement, right?
Right.
So he says, so August 1st, you keep security deposit and I take trailer and you sign title over to me. And you said, absolutely. I think that is fair. I was actually talking to Gail about that the other day. So you thought that was a fair resolution. So it seems like you guys had come to an agreement that they would move out August 1st. They had paid through the full month of July.
Yep.
And then you changed your mind because you thought they were going to damage the trailer that you said that you agreed that they could take on August 1st.
I changed my mind because of them threatening me when I was up there. So that regardless.
No, not regardless. This is the agreement that you had.
Okay.
Okay. All right. I'll make my ruling.
Yeah.
1 moment while I get my paperwork together.
It's not even in my name, so I don't know how you could do that.
Well, you were certainly acting with authority to do so. As you yourself had indicated in the text messages you sent. Stating, let's see. Did not leave Gail in charge of anything except collect rent. That's why I am on all bank accounts and I have full power of attorney and also have a quit claim to the house she lives in. Okay. So
that doesn't have anything to do with the rental agreement. I didn't write the rental agreement or the contract.
You have also testified under oath that you have authority to act on behalf of your mother-in-law as the property owner, and you hold yourself out to be managing the property, working with all these tenants the whole time.
Yeah, but I didn't put the terms in the rental agreement. That's not my handwriting.
Okay.
That's some cartoonist handwriting. I mean, look at it. Okay. It's an 80-year-old woman that drew it up.
Regardless, you are holding yourself out to be authorized to act upon it. You are texting the tenant saying you have authorization to do all of these things and then are threatening them to cut off water. So yes,
sorry.
You are holding yourself out to be that.
Can we please just make the ruling?
Sure.
Thank you.
All right. Firstly, I'm accepting all the exhibits in the file, so it's available upon appeal. In the small claims, Christopher Sims versus Christy Weicker, or Christopher Sims and Christy Weicker versus Dean Murray. We had an open court pursuant to a trial. Looking through the claim, I'm gonna have to get a calculator out for this one. So to start off with the easy one that's not in dispute, I am awarding the plaintiff $105 for the partial payment in the month of July. That is no dispute whatsoever. You had fully paid, and then Mr. Murray had basically cut off ability to enjoy the property at that point. So that shall be granted. I am going to grant the plaintiffs the entirety of their claim. To break it down, the sale and deposit was $4,750. So that would be $250 a month times 15 months, which is $3,750 plus the $1,000 security deposit, totaling that amount. I find that Mr. Murray was acting with authority for his mother-in-law. He was holding himself out. In fact, in his statement from the defendant here, it says, "So I run a small RV park for my mother-in-law. I have decided to rent to Chris and Christy." So he is acting as a landlord, and I will be holding him as such, at least having the authorization to act as a landlord. So with the sale and deposit, it does appear through text messages, exhibits 10 and 18 provided by the plaintiffs, that they had come to an alternative resolution to where they had indicated that they had paid the full month of July. They were intending to move out August 1st, and they were wanting to come up with a potential plan to pay off the rest of the fifth wheel. And you agreed that they had paid in full and called it fair, and they could take it on the first of the month. You changed your mind because of other things that came up, and you're concerned about them flooding the trailer, but I'm not lending any credence to that at this point. I find that the cutting off of water and the threats that were made by Mr. Murray to the plaintiffs, and Mr. Murray, just for the record, is off camera while I'm giving my ruling, so we'll continue to do so. There he is. All right, so with that, I also find that the plaintiffs, specifically Mr. Sims, had bought parts to fix up the fifth wheel. Because this was a rent to own, it makes sense. And even Mr. Murray said that it makes sense for them to fix it on their own behalf, right? So I am going to award the entirety of the amount to the plaintiffs.
Under Revised Code of Washington, Section 59.18.030, the court evaluated whether the defendant's conduct constituted an unlawful deprivation of essential services and interference with a tenant's right to occupy the premises. The court found that the defendant, acting with apparent authority as a landlord or property manager, engaged in conduct amounting to constructive eviction by cutting off water and restricting access to the property, thereby rendering the premises uninhabitable, despite rent being paid through the relevant period. Under Washington landlord-tenant principles, tenants are entitled to quiet enjoyment and lawful possession for the duration of the paid term. The court determined that denial of utilities and access without formal eviction proceedings violated these protections. The court further recognized a modified agreement between the parties, supported by written communications, allowing termination of the arrangement with transfer of the trailer upon agreed terms. The defendant's unilateral reversal of that agreement lacked legal justification. Accordingly, the court awarded damages for breach of agreement, loss of use, and reimbursement of improvements, totaling $6,455, plus $105 for prorated loss of use. No further relief was granted.